I think it's helpful to start out with two quotes that I think really frame the issues for this presentation. The first quote is from Chief Isaac of the Mississippi Band of Choctaw Indians during the hearings that led to the passage of the Indian Child Welfare Act in 1978. And he said, "Many of the individuals who decide the fate of our children are at best ignorant of our cultural values, and at worst contemptful of the Indian way and convinced that removal, usually to a non-Indian household or institution, can only benefit an Indian child." So contrast that with this quote from a California appellate case, which some of you may be familiar with, in Re Bridget R. "It is almost too obvious to require articulation that the unique values of Indian culture will not be preserved in the homes of parents who have become fully assimilated into non-Indian culture. The invalidation of the relinquishment manifestly can serve no purpose which is sufficiently compelling to overcome the child's fundamental right to remain in the home where he or she is loved and well cared for, with people to whom the child is daily becoming more attached by bonds of affection and among whom the child feels secure to learn and grow." You notice right offhand there a significant contrast in the aims of the different speakers, and I think that you'll see recurrences of this theme throughout today's presentation. So today we're going to first talk about a little bit of background about the history of federal, state, and tribal welfare relations. Then we'll talk about congressional hearings in the passage of the Indian Child Welfare Act in the 1970s. We'll talk about the application of the Indian Child Welfare Act and key provisions of the Act. We'll talk about the rise and decline of the existing Indian family exception, an exception that was developed by courts in the 1980s and beyond to try to get around the Indian Child Welfare Act. We'll talk about more recent federal and state court challenges to ICWA. And we'll also talk a little bit about recent revisions to the Bureau of Indian Affairs ICWA guidelines and proposed regulations. So starting with the history of federal, state, and tribal child welfare relations, so the history of federal policy toward Indian children and families tracks the history of federal tribal policy generally. As some of you are familiar with, the history of federal relations with tribes is a fraught one. Over the past 200 years, most of that time has been devoted to extermination or assimilation of tribes and eradication of tribal culture. And the history of tribal child welfare relations with the federal government and later state child welfare relations tracks a similar course. Before the Indian Child Welfare Act of 1978, policy both at a federal and state level favored removal of Indian children as a means of eroding tribal culture and effectively getting rid of tribes as governments and of cultures. During the late 19th and early 20th century, it's what's known as the boarding school era in terms of Indian children and Indian families. And two quotes really kind of set the stage here. The first is from 1867 from a report to Congress. "All experience has demonstrated the impossibility of educating Indian children while they are permitted to consort and associate with their ignorant, barbarous, and superstitious parents." And you see that similar theme of barbarousness played out in this other quote from 1876, advocating that all Indian children over 5 years old should be taken from the authority and influence of their savage parents, from whom they absorb only poisonous barbarism, and placed wholly under the control of white male and female teachers. And so this picture's of the Carlisle School, which was established in 1879 by Richard Pratt, who, there's a famous quote from Richard Pratt, "Kill the Indian, save the man." These schools were designed to assimilate children, remove Indian culture from their upbringing, and basically assimilate them into white society. This photo is a more close-up photo of children at the Carlisle School at around 1880. So during the 20th century, the boarding schools, federal boarding schools, gradually fell out of favor, and there's a shift in policy from federal relations with Indian tribes as it relates to families and children to state and private control over family matters, including Indian adoptions. And so this included the Indian Adoption Project, which was developed first by the Bureau of Indian Affairs, and in some ways was an extension of the termination policy then in vogue in federal tribal relations as a means of exterminating or terminating tribal tribes as governments and effectively making them private citizens and their members, removing the aspects of sovereignty. And so the Indian Adoption Project effectively replaced the boarding school era as a means to place children with white families. And by the 1970s, state child welfare agencies gradually took over control of Indian adoptions and Indian foster care placements and became complicit in the wholesale removal of Indian children. And so by 1974, there was a recognition that something was terribly wrong. The initial hearings at the congressional level were held. A number of American Indian associations, child psychologists, and others testified. There was a federal task force appointed, and the task force reported back to Congress some really shocking findings. Nearly 25 to 35% of all Indian children nationwide were being removed from their families, with a 90% on average placement rate in non-Indian homes. During the 1977 to 1978 period, there were additional congressional hearings held and extensive testimony from the executive branch, from various representatives of state child welfare agencies, medical and psychiatric professionals, tribal leaders, tribal members, and a variety of both Indian and non-Indian child welfare groups that revealed really the shocking removal rates, the fact that state child welfare workers frequently went onto tribal reservations and in many cases simply kidnapped Indian children from their homes for placement with non-Indian families in a process that bore little resemblance at all to the kind of due process that we're accustomed to now in state child welfare proceedings. Indian families were really targeted for removal, and there was also significant testimony about the cultural ignorance that drove these removals and placements. And also the consequences for Indian families and Indian children and tribes. The fact that tribes were being drained of, as one person put it, their most precious resource, their children. And the termination of tribal culture in that fashion, especially in such large numbers,